(850-683-1045).
Flowers, go ahead.
Your Honor, there is a substantive offense that's before the court, and on that matter, a bond has been established by the court, $3,500 cash or professional. There was a failure to appear for the reasons that I've discussed with the state and with the court that we don't need to reiterate. We're asking, Your Honor, he has retained Mr. Shaw and myself to represent him from the standpoint of setting a bond. He won't miss court. The reason he missed court was understandable from our perspective. We're asking that the court set some sort of signature bond with conditions in place, for instance, no contact with any alleged victim, witness, or party to this action. That's what we're asking the court to do, sir.
And the state?
Yes, Your Honor. First, the state asked the court to take judicial notice of 19 DR 543. That's the injunction against this defendant that was finalized on February 28, 2019, and it's the basis for one of the charges that he's currently facing. Defendant is currently charged with possession of weapon by convicted felon, which is a second-degree felony, possession of controlled substance, possession of weapon after an injunction. The evidence that in the case, the gun was found in the car the defendant was driving. The owner of the car consented to the search, and the gun was found placed between the driver's seat and the center console. The defendant made statements in his jail calls in February, admitting knowledge of the presence of the gun in the car. The prior record of this defendant includes a plea to the same charges of possession of weapon by convicted felon on April 13, 2021 in Santa Rosa County Case 5719 CF2110. His prior record also shows 3 possession of controlled substance charges, resisting officer without violence, felony tampering with evidence, possession of paraphernalia, lewd and lascivious battery on victim 12 by 15 years old, failure to register as a sex offender. He scores a minimum of 34 months DOC and a maximum of 20 years. The current offer in the case is 35 months DOC. As the court is aware, defendant failed to appear on March 30, 2023. The victim of the injunction has expressed fear. She feels threatened by the defendant because he was caught with a gun when he shouldn't have possessed a gun. The victim has asked me to read a letter she provided. May I be allowed? June 8, 20, to the Honorable Judge, I'm writing as a victim of David Joel Rodriguez. I was granted an injunction against him in 2019 by Judge Brown in Okaloosa County. In 2019, he violated the injunction. He has continued to terrorize me in cyberspace since then. He has violated the injunction again this year. In January 2023, I found out by looking at the FDLE site that he had moved on the next street over from mine, less than 1,000 feet. He was seen again by me sitting in front of my house in a car, intimidating. I couldn't capture a picture fast enough. I did call law officers and make a report, which led to him violating the injunction once again. I have lived in fear for my life the last 3 years while he's in and out of jail. I feel afraid for my life and multiple other victims he preys upon if he is released on bond. Prior to the first injunction, he threatened me over 50 times a day by text, sitting on the street where I live, sitting in my driveway in his car, threatened my family, my children, and said he would burn my house down. He has committed cyberspace crime against me and tried to ruin my career. He has great pathology, and I'm afraid for my life and my family if he's bonded out. Please keep this man in jail so he will not continue to prey on others. Thank you for your consideration. Susan Shelton. Your Honor, the state asked this court to deny defendant's motion. If the court is inclined to grant pretrial release, then the state asks for at least a $10,000 cash or professional bond and GPS monitor. No contact with the victim.
Judge, if I
Having
might,
said all that, the history and everything, my understanding is he was granted a bond by some other judge and he was out on, correct?
That is correct, Your Honor. He has bonds.
There was no violation of the bond except that he failed to show up for court. Is that my understanding?
Correct, Your
So this
Honor.
is a failure to appear issue in front of me, not all that other that some other judges set a bond, correct?
Yes, Your Honor.
And I believe there was some type of medical issue with a loved one is the reason he didn't make it to court that day, or is that the allegation or the Mr. Flowers?
Your Honor, that's exactly correct.
All right. Well, some other judge gave him a bond on all that history that you recited to me. The issue before me is his failure to appear, 10,000 signature bond, ankle monitor, no contact with the victim.
Thank you, Your Honor.
Thank you. Your Honor, that's all I have before the court today. Thank you, sir. Do you know what that means? You're going to sign out today.
Okay, thank you, sir.
Call us.
Mr. Green,
Ms. Misc, step out. Can you pass on me for 1 minute? I'll step out to get my client.
sure. Who wants to go next, Miss?
Morning, Your Honor. Cheryl Gooden for Courtney Howard.
For Courtney Howard?
Director. We are here before the court on a violation of probation.
Okay.
Understanding that it's the first appearance, it is a misdemeanor. My client would admit the violation. We would ask the court to restore her to probation. She's already been adjudicated because it's a DUI. We have resolved the driving while license suspended. She has been placed on 6 months probation, there 30 days house arrest.
Do we have a plea form? Is that what you're doing?
No, Your Honor, we're pleading straight to the court. The state attorney did not agree. She wanted jail time.
Oh, well,
May I, Your Honor, the offer that I have, because I didn't understand, is to reinstate probation and 30 days house arrest.
to reinstate probation and 30 days house arrest?
Yes,
For an admission to the violation of probation?
yes, Your Honor.
Is that what your understanding was?
Our understanding was 30 days county jail.
Well, I mean, can you all talk about it and get it straightened out? I mean, I'll give her the 30 days house arrest. I don't want to put anybody in jail if I don't
Right,
have,
right.
you know.
We can pass it for a second.
Y'all want to make sure you understand what just to have a clear understanding of what you're
I'm
asking.
just asking for reinstatement and 30 days house arrest, not jail.
Okay, you want to admit, does she want to admit violation?
Yes, Your Honor.
What's that court number?
It's 22 CF 2983.
And her name again?
Courtney Howard, Howard.
All right. Ms. Howard, would you raise your right hand to be sworn? You swear the testimony you give before this court is the truth, so help you God? You do? All right. You want to admit that you violated probation, is that correct?
Yes.
You don't have to keep, okay. Are you aware of the rights you're waiving by entering this admission?
Yes.
Has anyone forced you or threatened you to enter this admission?
No.
Are you satisfied with the work your attorney's done for you on your case?
Yes.
Are you under the influence of any medication or drugs that would prevent you from knowing what you're doing here today?
No.
Court finds the admission is freely and voluntarily entered. Court will accept it. Reinstate probation on the original terms with an additional term of 30 days house arrest. Unless, I guess, she has to go to the emergency room or something, or is that?
Yeah, it can be adjusted based on our schedule,
What
work
about,
schedule.
and work?
Yes, Your Honor.
All right, and work?
Yes.
Okay, you can go to work or, all right, but other than that, you got to stay at home for 30 days, okay?
Yes.
And Your Honor, to make sure with the lower court, the Judge Selectors, we waived the cost of the GPS, or did not make her wear an active GPS?
Well, just whatever the same terms are,
Okay.
okay?
Thank you, Your Honor.
Thank you.
Your
And-
Honor, your Charles Bear with state probation.
Okay,
He's being supervised by the misdemeanor
JCS.
probation office, just so the court's aware. So this would be house arrest with judicial services,
oh, all right.
not with
Is that
us.
a problem with that?
aware
Okay,
of that.
all right,
And we'd ask that it run concurrent to the misdemeanor.
okay,
Thank you, Your Honor.
Thank you.
all right. Mr. Green?
Good morning, Judge. John Green, appearing on behalf of Victoria Ashley Cameron in case number 21 CF 1558. We are before the court for a change of plea. My client will enter a plea of no contest to one count of misdemeanor stalking. Adjudication will be withheld. The terms and conditions of the plea are set forth in the last page on the addendum. May I approach?
All right. All right, you're Victoria Cameron?
I am.
This is 21 CF 1558. Would you please raise your right hand to be sworn? You swear the testimony you give before this court is the truth, so help you God?
Yes.
You want to enter a no contest plea to one count of misdemeanor stalking. That is a lesser included offense of count one. Is that correct?
Yes, Your Honor.
And what about count two?
Dismiss count two.
And the state's going to dismiss count two. So you want to enter a no contest plea?
Yes.
To misdemeanor, okay. Are you aware of the rights you're waiving by entering this admission, or this no contest plea?
Yes.
Anyone forced you or threatened you to enter this plea?
No.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Green's done for you on your case?
Yes.
Court finds the plea is freely and voluntarily entered. Court accepts it. Placed on probation, 11 months, 29 days. You will be allowed mail in or phone in probation. You have to submit to a mental health evaluation and follow any recommended treatment. Attend anger management class. Have no contact with victim Mackenzie Faith Cameron. Perform 50 hours community service with the option of buyout at statutory rate $11 per hour. Pay a monthly service fee of $41. No early termination of probation will be permitted. Pay $572 in fines and costs to the clerk of court. Pay $150 of costs on prosecution to the clerk of court. Any cash bond shall be applied to costs and fines, and adjudication is withheld. Anything further?
Nothing further, Your Honor. Thank you.
Thank you.
Your Honor, in order to COS, we request that COS fees be waived since she's going to be mailing in a report.
Okay. Mr. Stewart?
Good morning, Your Honor.
Yes.
May it please the Court, Brad Stewart, on behalf of Samuel Hyde, Judge. This is 22 CF 241. Judge, we set this case on the court's docket today for status purposes. We have some additional information that we are turning over to the State Attorney's Office. We do need to continue this one cycle in order to perfect that. I anticipate advancing this on the court's docket once we provide that to them and they have a chance to review it.
No objection.
August 28th.
Your Honor, my next client is Mr. Ben Kimbrough. Mr. Kimbrough is present. And for the record, Your Honor, this is Ben Wilkerson Kimbrough, Judge, 2017 CF 2161. We're before the court with regards to our motion for early termination of probation, Your Honor. Inasmuch as Mr. Kimbrough was entered a plea on June 21st, 2018, to 10 years of secondary probation, Judge. He has successfully completed 5 years of that supervision at this point, which of course is at the halfway point. All special conditions have been completed. There is no outstanding financials, Judge. There was one technical violation due to GPS monitoring equipment. Mr. Kimbrough does live in the Escambia Farms, North Okaloosa area, and there was a signal issue there. We have remedied that, and he has been violation-free, technical or otherwise, since January of 22, Judge. He has complied again with all terms and conditions of his probation. We did contact his probation officer, and of course, due to the nature of the offense, probation cannot recommend early term. However, according to Officer Beck, there is no reason this case cannot be reviewed and considered as he's completed the special conditions of supervision, Judge. That is our request.
Your Honor, the state does object to early termination. As the court is aware, the general standard is, first of all, 2/3 completion, and that is without any violations. As Brad Stewart has already mentioned to the court, there was a violation, so that would take him out of that specific consideration. But more importantly, Your Honor, Mr. Kimbrough was placed on 10 years of sex offender probation based on the nature of the charges. We felt that he is a danger to children. We must keep an eye on him supervised. He also has a 10-year suspended sentence, which is still hanging over his head. We wish to keep him on probation because we believe it is important to assure the safety of children and to assure that he is in compliance with the rules and conditions. If he chooses not to be, then we still have to suspend him. So we do feel like he got the break up front, and he got the benefit of that bargain to be placed on probation versus to be sent to USC directly, which he did score out. So we are asking the court to not allow him to terminate early, to keep him under supervision.
Yeah, getting 10 years probation instead of 10 years DOC is quite a significant benefit. So at this time, I'm going to deny the request for early termination.
Understood, Judge.
Thank you.
Your Honor, my next client on today's docket is Mr. Tyler Mills. This is 23 CF 706, Your Honor. We initially set this on today's docket in anticipation of entering into the PTI program. Mr. Mills' mother contacted my office on Friday. He was admitted to the hospital, Judge. He is still in ICU at this point. I don't know the exact prognosis. I did speak with his mother directly, and she did confirm that. Judge, at this point, I would like to do a full continuance until I can get a better handle on the prognosis, and then advance this on the docket so he can complete the PTI program.
No objection, Your Honor.
All right, what about August 28th?
No objection.
Okay.
Very good, Your Honor. Your Honor, that's all I have before the court. May I be excused?
Yes, thank you.
Thank you, Your Honor.
Mr. Nopes?
Judge, the first case I have is Louis Osty. Yeah, I got out of custody. Judge, the out of custody I have is Mindy Collins.
Collins? She here?
Well, Mindy, let me take Ms. Collins, yes. I'm sorry, I should have taken Bly. Judge, may I approach?
All right, you are Mindy Collins?
Yes.
This is 22 CF 2706, State versus Mindy Collins. And you want to enter a no contest plea to DUI with injury or property damage, a first-degree misdemeanor, is that correct?
Yes.
And the state's going to dismiss count one.
Yes, Your Honor.
Would you raise your right hand to be sworn, Ms. Collins? You swear the testimony you give for this course is true, so help you God?
Yes.
Did you read and sign this plea and sentencing agreement form?
Yes, I did.
You understand the rights you're waiving by entering this plea?
Yes, I did.
Anyone force you or threaten you to enter this plea?
No.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Are you happy with the work Mr. Nopes has done for you on your case?
Absolutely.
You got an absolutely there, Mr. Nopes.
Got that going for me, Judge.
All right. Court finds the plea is freely and voluntarily entered. Court accepts it. Adjudicated guilty, 1-year probation with following special conditions, $500 fine and $463 court costs plus $50 cost of prosecution, 50 hours community service work or buyout at $11 per hour, complete DUI school or show proof of completion of DUI school, complete the victim impact panel, 6 months driver license suspension. You're allowed to have a hardship permit if you qualify for one, and a 10-day vehicle impound. And adjudicated. Is there anything further?
Yes, sir.
Okay.
Thank you, Judge.
Yes?
Oh, okay.
What'd you say? Yes. Judge, Mr. Osty is back on the docket, and I'm assuming at this point, I don't know for sure why it got set for hearing, but I guess it just needs to be put back in the pretrial conference on the 28th.
Yes, Judge. We would have no objection to the court considering the evaluation that's been updated, finding him competent to proceed, and putting him on the next pretrial docket.
August 28th then. How about that?
Yes, sir, we're going to try to work it out prior to that, and if we do...
Okay, if you
we'll be
do, we'll move it up so we can get his case resolved.
back. Come see you, not this weekend, but I'll come see you, okay?
Yes, sir.
Judge, then I had out of custody Chad Blotta. Judge, we've agreed to continue that, and I think there is a docket on July 25th.
You want to continue it from that date or to just?
To that date. to
Okay.
July 25th.
All right, thank you, sir. July 25th.
Good to go. Judge, Mr. Grantham's case, we filed a motion to reinstate his bond. He was out on bond on this 23 CF 34 case, and he got arrested on 2 misdemeanors that have now been resolved. They pled out, so we're simply asking the court to reinstate his bond on this underlying case.
with the same condition that it was before, I'd be fine with that.
Okay, I'll reinstate your bond. You want to get out of jail? I'll reinstate your bond.
Yes, sir.
Okay, same conditions.
Thank you, Judge.
What's his next court date?
Judge, I think we'd already put it, no, we didn't. That's a good point. We need to put it on August 28th, Judge.
All right.
Good. Judge, may I approach?
Yeah.
For the purpose of this plea, we're stipulating that the court has jurisdiction to resolve that 22 MM 3135 misdemeanor case.
Is this some pending case in front of Judge Ward or some other county judge?
Judge, the misdemeanor case is pending in front of Judge Ward, but the state and I, through Marshall Mull, who's the misdemeanor prosecutor, stipulated that on the 22 MM 3135, he'd be sentenced to time served. Terminate and revoke, time served. We're trying to get him to a treatment center in Panama City Beach.
Sort of hesitant to do that without Judge Ward knowing about it. So can y'all contact Judge Ward and bring him back in a few minutes? And
That'd be fine.
I think something came up about, I don't have any problem with it, but I'd prefer Judge Ward to say that's fine. It's Judge Ward's case. I don't know if I can change. I don't think I can, even with y'all's stipulation.
If you'll hold on to that just a second, I'll go to his office. I need to go talk to Judge Overleeson for a second, but then I'll go right to his office. You
Okay,
can just
y'all
hold
talk
for
to
a minute.
him, Judge Ward, and see, and let me give you this back. You can, if you wouldn't mind, get him to initial off on that or something.
Be right back. Last one I had, Judge, I'll be right back to.
All right. Ms. Flowers. Morning.
May it please the court, Jennifer Flowers on behalf of Daniel Whitted. We're here today in case number 21 CF 3051. It's a violation of probation. We've reached an agreement with the state. May I approach?
Mr. Whitted, would you, you're Daniel Whitted, would you please raise your right hand and be sworn? You swear the testimony you give before this court's the truth, so help you God?
Sir.
Okay. This case 21 CF 3051, you want to admit that you violated probation? Is that right?
It's an admission.
You want to admit
Yes, sir.
you violated probation? All right. Are you aware, did you read and sign this violation of probation plea agreement form? Oh, yeah. All right.
It's the same agreement we went over.
All right, you've read and now you've signed this plea agreement form, sir?
Sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevents you from knowing what you're doing here today? Are you happy with the work Ms. Flowers has done for you on your case?
Yes, sir.
Court finds admission freely and voluntarily entered. Court accepts it. Court adjudicates you guilty, reinstates community control, reinstates all prior terms and conditions to include 42 months suspended DOC sentence, $100 VOP cost of prosecution, $150 cost of defense, $418.30 cost of transportation to Okaloosa County Sheriff's Office. So you got a 42-month suspended sentence, so Ms. Flowers must have done a wonderful job for you not to get a prison sentence, so don't mess up, okay?
Sir.
Okay, thank you.
Your Honor, he was previously, his cost of supervision was waived. We request it remain waived.
Okay.
Your Honor, Jennifer Flowers on behalf of Carly Elizabeth Bello. We're here in case number 23 CF 1209. We're here on a bond, motion to reduce bond. Your Honor, Ms. Bello currently has a bond in the amount of $75,000 cash or professional that was set at first appearance. She was arrested on or about June 1st, 2023, and charged with lewd and lascivious battery of a victim 12 to 16. Since then, the state has filed a formal charging document that has changed the charge to an unlawful sexual activity with certain minors, which is a different charge. Obviously, the defendant has been found by the court to be indigent and cannot reasonably afford to post such a high bond. She resides locally with 2 minor children, for which she is a primary provider, both financially, and the children were living with her prior to this. She has a job at Domino's where she's worked for over 5 years. The defendant has no prior failures to appear because of the new charge and because she's not a flight risk and there's no alleged violence in this case. We're asking that she be released on her own signature.
Judge, we believe the bonds are appropriate as set. She was charged with unlawful sexual conduct with certain minors. State did amend that charge from lewd lascivious battery based on the age of the victim. Basically, in 2021, the then 28-year-old defendant is accused of having sex with her 16-year-old babysitter. As charged, she scores 66 months in the Department of Corrections, the maximum of 15 years. Given the totality of the circumstances, if the court is inclined to reduce the bonds, we would ask for at least $20,000 cash or professional with Level D pretrial services to include GPS, in-person reporting, no contact with the victim or his family, no unsupervised contact with minors, and do not be where they congregate.
So this charges have nothing to do with her children, is what you're saying?
That's
It's
correct.
some other.
And Your Honor, and we're not aware, I don't believe we've received the full discovery exhibit yet, but we're not aware, at this point, the allegations are the witness, the alleged victim, and basically his word against Ms. Bello's word of what was going on at that time. Again, she has no prior failures to appear. She has ties to the community. She has a job, has a home that she's maintained even while being in jail. She needs to get back to work so that she can provide for her children.
The state has filed lesser charges than what she was arrested for? A lesser,
It was originally a lewd lascivious battery. However, because the victim was actually 16 and not 15 at the time, we amended the charges.
down to what, a second-degree felony from the
Yes.
first or something?
It's a second-degree felony.
What bond are you asking for?
$20,000 cash professional.
And we would ask for 20,000 signature. She doesn't have the ability to post that type of bond.
she have a prior record?
She has a 2019 drug charge that she received successful pretrial intervention for, and that's the only thing that was showing.
Other than a PTI, no prior criminal history.
20,000 signature, no contact with the victim, GPS monitor.
Thank you, Your Honor.
And the next court date? August 28th. Okay, thank you.
Thank you. Just be in
Your
touch.
Honor, that would include pretrial services level B.
Yes, pretrial services supervision.
Your Honor, this is Shamika Hutchinson. We're here in 23 CF 977. She came for pretrial the other day and was arrested on a warrant for a violation in her misdemeanor cases based on this violation. I have been in contact with Marshall Mull, the ASA, on those cases, and he is, I don't believe he is agreeable. We were hoping that today that we could enter a global resolution and get her on probation, but I don't believe he's agreeable to that at this point. So I would just ask for a continuance in this matter, and it seems that we're going to have to address that VOP in misdemeanor court in front of Judge Ward.
Okay, well, if you can get it resolved, we'd bring her back as soon as possible so we can, if it results in her getting out of jail, that, you know, I'm all for that.
Yes, Your Honor.
So as soon as you can.
Could we put her on possibly for, just bring her back on docket day and just see if I can work a little harder and get this resolved with Ms.
Okay,
Okay.
July 3rd.
Okay.
And
thank you.
hopefully you can get out, get it
I'm
resolved.
doing what I can. I'll come see you before that, okay? Thank you, Your Honor. I have one more on the docket. Oh, do you have one more for me? Oh. All right, I was not aware of this.
She's my client, Ms. Flowers.
Oh, okay. Oh, that's okay. This is
Ms.
Baker? Okay,
Yeah, this is
sure.
Ms. Baker.
This is Mr. Gibbs' client. I've got to go look for a client on the custody.
Good morning.
Good morning.
Your Honor, Tim Gibbs on behalf of Jenny Lynn Baker. This is 22 CF 2998, 23 CF 712, 23 CF 713, 23 CF 1372. Judge, we have an agreement if I may approach.
All right, you're Jenny Lynn Baker.
Yes, sir.
Would you raise your right hand and be sworn? You swear the testimony you give before this court's the truth, so help you God?
Yes, sir.
You want to enter a no contest plea and an admission of violation of probation. In 23 CF 1372, you will be entering a plea to a misdemeanor, possession of paraphernalia, and also admit that you violated probation in 22 CF 2998, 23 CF 712, and 23 CF 713. You understand that?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Did you read
Yes.
this? Oh, I'm sorry. Go
Are
ahead.
you aware of the rights you're waiving by entering this admission and plea?
Yes, sir.
Anyone forced you or threatened you to enter this admission and plea? Were you forced or threatened to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevents you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Gibbs has done for you on your case?
Yes, sir, very
Court-
much.
Okay. Court finds the admission and plea is freely and voluntarily entered. Court accepts it. On the misdemeanor, your charge, you are sentenced to time served, $100 cost of prosecution, $220 court costs, $150 PD fee, and payable while on supervision in the other cases. And in the other cases, the violation of community control, the court's going to reinstate to original terms and conditions, 18 months community control, followed by 12 months drug offender probation. Supervision beginning 5/16/23, complete original requirements, modifying to add $300 cost of prosecution, $300 total for all the cases, $300 PD fee total for all the cases. Enter and complete intensive outpatient program, enroll within 30 days of release if not available locally. Complete a substance abuse evaluation, enroll within 30 days of release, and enter any recommended treatment. Begin treatment within 30 days of evaluation, and court's going to maintain withhold of adjudication on all cases. So, get all that done.
1 second. May I,
I've got withhold and adjudicated, both checked.
Okay, I'll read it from now on, Tim, I'm sorry.
I'm sorry, I've got 23 CF 1372 adjudicated, and on the 22 CF 2998, 23 CF 712, and 23 CF 713.
Those are the case numbers, Judge. I think we've resolved the issue.
Which is it?
There was a concern if she was going to still maintain her withhold, Judge. But
Is
I think
she?
at this point, we've resolved that. The written plea agreement reflects that. I previously sent the agreement to Ms. Leone via email for her to review to make sure that all of the terms were stated as we had agreed upon.
Well, you have withheld check and you have adjudicate check.
And above each one, it lists the case numbers. for
Okay,
which-
so according to that's the way it's going to go?
Yes,
Is
Your
that
Honor.
right, Ms. Leon?
Yes, Your Honor, I made a mistake, so I'm going to stand by my signature.
Okay. All right, well, adjudicated on the misdemeanor and withhold on the VOCCs, so, okay.
Thank you, Judge.
Thank you.
And of course, just for the record, we want to make sure that supervision fees are still waived.
Yeah.
Court would so be so inclined. Thank you.
Okay.
And Your Honor, just for housekeeping purposes, we can get her referred to Bridgeway in that 30 and 60 day, but we can't make them see them. Here's what's happening in our office. When we're asked to do this, and they don't get the evaluation done within 30, we're coming back with a VOP. And that's not fair on her, or if they can't see her within that period of time. But this is our marching orders, and I just want to kind of make the record clear that if we can just do away with that, I promise you we'll send them. I can't promise you when they can see them.
So, Mr. Berry, I kind of anticipated that. The agreement says that she needs to make an appointment, schedule an appointment within 30 days of her release, and then if any treatment that's recommended should start within 30 days of that recommendation. If that's still a bit much.
Well,
for
what
her
about
standpoint.
get the treatment as soon as available?
Right.
How about that? That's what my standing order will be. As soon as it's available, she has to make an appointment within, say, 30 days, but as soon as it's available, then I don't want anybody to go to jail, especially for something like that. I mean, so,
I understand what the court just said, and I will address that with
Yeah.
the Department of
well,
Corrections.
yeah, I don't want anybody to
I
get
got it.
a violation. I don't want anyone to go to jail or prison if at all possible they don't, so, I mean,
Okay, thank you, Your Honor.
Thank you, Mr. Berry.
Okay, next, Mr.
Do you have anybody else lined up? Okay, that's fine.
Mr. Powell, or Mr. Nopes, you back, okay?
I got Judge Ward to sign the agreement, Judge.
Okay,
Approach.
yeah.
Mr. Knopf, of the score sheet, please.
So Judge, we're back here on 23, on Dakota Gregory Josie, 23 CF 1095, 23 CF 1330, and 22 MM 3135C. Judge, the defense and the state are agreeing you've now got jurisdiction to resolve the misdemeanor for, he'll admit he violated his misdemeanor case, and he would get time served for that, and then the details of the plea otherwise is on the plea agreement.
Okay. Mr. Josie, would you please raise your right hand to be sworn? You swear the testimony you give for this court's truth, so help you God?
Yes, sir.
All right. This is State of Florida versus Dakota Josie, 23 CF 1095, 23 CF 1330, 22 MM 3135. So you want to enter a no contest plea and admit violation of probation. Is that which one of these is the VOP, Mr.?
The VOP is 22 MM 3135.
Oh, okay. All right, so you want to enter this admission and also a no contest plea to these charges of possession of narcotics equipment, moving traffic violation with suspended license, drug possession without a prescription, narcotics possession, and another driving with license suspended. So those and the misdemeanor VOP.
Sir.
Okay. Did you read and sign this plea and sentencing agreement form? Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
And admission? Okay. Anyone force you or threaten you to enter this admission or plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Nopes has done for you on your case?
Yes, sir.
Mr. Nopes, would you have him sign this agreement?
Sorry, Dakota. I didn't. We got confused.
You related to a Ben Josie?
No, sir.
No? Okay.
Related to the Mike Josie and Crestview.
All right. The court finds the admission and no contest plea is freely and voluntarily entered. Court accepts it. You're adjudicated guilty on all cases and counts, and the defendant is sentenced to time served on 22 MM 3135 and 2 years probation on the felony cases with the following special conditions: 615 court costs on 23 CF 1330 and standard court costs on 23 CF 1095, successfully complete intensive treatment at Recovery Bay Center, 9721 Thomas Drive, Panama City, Florida, and waive costs of supervision.
Judge, he entered misdemeanor pleas in the 23 CF 1095. I didn't know how much the misdemeanor court cost was.
270?
I'll impose a standard misdemeanor court costs on the misdemeanors and adjudicate it on everything. Is that correct?
Correct.
Okay, thank you.
Thank you, Judge. Thank you, Judge. I'll have a written decision.
Next. Okay.
Ms. Trimble? Your Honor, Jennifer Flowers with RCC on behalf of Alyssa Trimble, case number 20 CF 222. This is a VOP. We've reached an agreement with the state that she's going to admit the VOP and reinstate probation. If I may approach. Let me make sure everybody's signed. Yep.
Ms. Trimble, would you please raise your right hand to be sworn? You swear the testimony you give for this court is the truth, so help you God?
Yes, sir.
This is case 20 CF 222, State versus Alyssa Trimble. You want to enter an admission that you violated probation, is that correct?
Yes, sir.
You can put your hand down. Has anyone forced you or threatened you to enter this admission?
No, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this admission?
Yes, sir.
Are you under the influence of any medication or drugs that prevents you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Flowers has done for you on your case?
Yes, sir.
Court finds admission freely and voluntarily entered. Court accepts it. Court will maintain withhold of adjudication, modify, and reinstate to extend 12 months to complete all original terms and conditions, $100 VOP, cost of prosecution, $150 cost of defense, waive cost of supervision, may perform community services for all eligible fines and costs. And that's it, right? Okay.
Thank you, Your Honor.
Thank you. Did I miss something?
Yeah, we're just trying to figure out. Yes, one moment. I'll have to pass her and come back, I think.
Didn't I announce something on that?
Yes, I had thought that that was the agreement for a withhold, but
The
I'm
offer
being
was
told.
an adjudication.
Is what?
The offer was an adjudication. We were just double checking to make sure there wasn't any other communications where a withhold was conveyed. But I can't find any, so the offer was an adjudication.
Oh, so you want to talk to your client about it?
Yes, Your Honor.
Okay, we'll bring her back in a few minutes. Next, Mr. Powell.
Yes, Jason Miles. Bo Powell for the record on behalf of Jason Miles. There's 3 cases on the docket, Judge. The state and I are in agreement to pass this to your August 10th date. We're working on a resolution.
I got an August 28th. You want a miscellaneous August 10th? Okay.
Yes, sir, I think
Okay, good.
I think that'll be.
Yeah,
gives
we'll
enough
do
time.
that. I mean, okay.
Very good.
No objection, I guess, so go ahead. August 10th.
Thank you, Judge. Have a good
Thank you.
day.
Thank you.
One of y'all come upstairs to jail sometime? Yeah, he's coming. Okay. He keeps, but he hasn't came and saw me yet.
Oh. Is Elijah Harper on the docket? That was a,
Well, we'll just figure it out, and then we'll come back in a minute.
well, I believe, I don't know if she's present or not. I'd ask for just whatever the next available date is for Ms. Harper. I thought I saw that on the docket for your pretrial date, so I thought it might have already been
August
addressed.
28th?
Perfect.
Okay. Is it to a misdemeanor or
I
something?
believe there is a misdemeanor plea.
Is
but
this,
that's-
is this Mr. Dixie Powell's
It
case?
is. It is.
Okay.
So that's my limited knowledge of the matter.
Okay, he just got a $3 million verdict on a case the other day. He probably got his mind somewhere else on this. But,
I need to get
is
a-
he supposed to be here today?
He asked me to cover, he was in Pensacola on a matter.
Okay, so, well,
I didn't know that one was on the docket. I thought that was set for your pretrial date. I thought it had already been addressed.
Bring it back July 3rd. Is Mr. Dixie Powell going to be around July 3rd, or? I bet.
I will relay the message.
We'll go with July 6th then, July 6th.
No, thank you.
Can you tell Mr. Powell to get
Yes, I will relay the court's.
July 6th, okay?
July 6th.
Get it straightened out.
Very good.
Okay, thank you.
Thank you, Judge. Have a good day. I'll take care of that.
Yeah, I guess so. And you are, good morning, you are Oakley Kimbrell, is that right?
Yes, sir.
Okay, good. What do we got here for Mr. Kimbrell? What's he charged with?
I'm not charged, well, I was charged with eluding the lascivious battery.
Mr. Berry, hang on one second.
Your Honor, Mr. Kimbrell is not in violation status, number one. He has a 3-year-old sister that resides with him and his parents in North Baker. The order says no unsupervised contact with minors.
Uh-huh.
We have reached out to the court for guidance on, is he able to stay in the home with his 3-year-old sister if his parents aren't there?
Judge, I believe this is Ms. Basso's case. I believe she stepped out just for a moment. If we could recall him in a few.
Yeah, let's let her have a chance to say something, so I'll consider whatever it is in just a minute.
Right,
Okay.
we just reached out for guidance from the court.
I got you, that's good.
Not as a violation.
All right. All right, well, here she is. Hang on one second. Yeah, this is Mr. Kimbrell.
I thought it looked familiar.
Okay, Mr. Berry's looking for guidance on whether he can be around his sister,
Your Honor,
Unsupervised.
unsupervised.
Your Honor, based on the nature of the underlying charges that Mr. Kimbrell is actually on supervision for, the fact that we do feel that he does pose a danger to children if he's unsupervised, we are objecting to the unsupervised contact with the child. Supervised, certainly that's fine, but unsupervised contact, no. Based on the nature of the charges and his status, we don't believe that.
How long has he been on probation?
Close to a year,
How long has he got to be on probation?
2 years, sir. I'm almost done with it. What we're asking is just to have unsupervised contact with my sister. And not saying that I'm just going to be left at the house alone with her. It's just that sometimes, say we're out drinking coffee, me and my parents were drinking coffee, and I can't go inside the house because Peyton's there. So, I can't go inside, get another cup of coffee, or I can't go inside, brush my teeth.
He's almost finished with his probation.
He's on probation till September of 2024, Your Honor. I think he did this was a split sentence, if I'm
Yes, sir, I
saying this
did 4 years in prison.
He did a DOC sentence and came out with supervision to follow.
Yes, sir. And matter of fact, Judge Flowers was my judge at the time. Peyton wasn't even conceived yet. She was adopted. It wasn't a thought, so we never even.
I'll allow it.
I'm sorry.
I'll allow it.
Yes, sir.
Okay.
Thank you.
Your Honor.
Thank you.
Thank you, Your Honor.
Stewart? Mr. Stewart, what you got
I
today?
got a violation of probation, felony.
What?
Violation of felony probation.
Violation of probation?
Who is this, Judge?
He's what?
Who?
Delvin Stewart.
Number 9.
Your Honor,
This defendant's here for a violation of probation. For a positive drug test, and I don't think you have an attorney, but I do have an offer if he wishes to take that today. It's to reinstate probation and extend probation by 6 months from your original termination date, and then complete a substance abuse evaluation and receive any counseling or treatment as needed. And once that's completed and you can show completion to your probation officer, your supervisor will automatically terminate once that's completed. And it would come with an adjudication of guilt.
Want
But
to do that?
he's already been convicted, I believe.
Want to do that?
Yes, Your Honor.
Would you please raise your, what's that case number?
It's
Miss,
2018 CF 2092.
2092. And it was Mr. Oakley, is that correct?
This is
This is Mr. Stewart.
Dylan
Stewart, I'm sorry, Mr. Stewart. I don't seem to have him on. Okay, well, Mr. Stewart, would you please raise your right hand and be sworn? You swear the testimony you give before this court is true, so help you God. You want to admit that you violated probation?
Sir.
You understand the rights you're waiving by entering this admission? Anyone force you, threaten you to enter this admission?
Sir.
You under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Are you happy with the work you've done on your case for yourself?
Yeah.
All right. Court finds the admission is freely and voluntarily entered. Court accepts it. We'll adjudicate, reinstate probation with an additional 6 months probation, the same terms and conditions, but enter outpatient or do an outpatient drug evaluation, do any recommended treatment, and if you do that and get it finished before the 6 months, your probation can terminate early. The 6 months part, correct?
Yes, Your Honor.
Okay, so get that done, and then you'll, anything further?
$100 cost of prosecution.
$100 cost of prosecution. Thank you.
Approach to the score sheet.
Yeah.
Your Honor, from probation standpoint, you've already paid all your money? He'll be able to pay the $100. Your Honor, his original termination date is July the 26th of 2023. We're going to go 6 months from there. Is that appropriate with the court?
Yeah.
Okay, thank you.
Okay.
The last pro se is Victoria White.
Ms. White? Is that you, ma'am? Okay, come on up. Okay, all right, what do we got from Ms. Victoria
Your Honor, this is
White?
20 CF 1678. Ms. White's here on a violation of probation. The last time we were in court, the state offered Ms. White a continuance in order to complete the Bridgeway program. If she could show proof today, then we would agree to terminate her probation and dismiss the VOP. So, Ms. White?
You did your Bridgeway program?
No, I didn't, because whenever I got put on probation, it was COVID and everybody was locked down, and so I didn't go. But I can tell you what's wrong with me without going to Bridgeway.
No, you got to go to Bridgeway to get your probation, terminated? So,
Okay.
What are we here, on a violation of probation?
Yes, sir.
Do you want to admit you violated? And,
No, sir.
Okay, well, then we'll have to set, when's our VOP hearing dates?
We could set it at the end of July, Judge. 25th, Madam Clerk? 27th?
27th,
27th.
July 27th, okay? Then I'll hear what you have to say.
Judge, does she need to apply for a public defender?
Yeah, matter of fact,
I'll defend myself because...
You don't want a public defender to help you out?
No, sir.
Okay. Thank you. Next.
Your Honor, I have a Mr. Charles Detz.
Debts.
Your Your Honor, we filed a motion to withdraw yesterday due to a conflict. I did relay his offer to him, but of course, due to the conflict, that prevents me from being able to advocate for him.
To appoint regional conflict counsel? Okay, you have a conflict of interest?
Yes, Your Honor.
I'll let you off and give you regional conflict counsel. It's at no charge to you, sir. Okay, thank you.
Thank you, Judge.
Ms. Flowers is right there.
Otherwise, Judge, we probably would have to continue his case. to-
August 28th, Ms. Flowers.
So-
Yeah, I think that would be best.
Okay.
Can we recall Ms. Trimble?
Okay.
And, Your Honor, if we could retrieve the previous plea, we think we're just going to make a couple, the state and I have agreed to kind of a compromise.
Steve, can you give that to her?
Going to admit the violation, maintain the withhold, but she's not going to be able to early terminate her probation. She'll have to do the full 12 months.
Okay.
No. So I'm adding in no early termination.
All right.
And on this one, it's the intent to extend 12 months from the original termination date, which is August 13th.
All right, Ms. Trimble, you understand this modification of sentence that's your attorney's announced?
Yes, sir.
You're agreeing with that?
Yes, Your Honor.
Okay, the court will modify the sentence as to withhold adjudication, but no early termination, and it's extended 12 months from the date of the original sentence. Is that good, Mr. Berry?
Thank you.
Okay, anything else?
No, Your Honor.
Thank you.
Thank you.
Thank you.
Great, thank you.
All right, who we got? Miss Rivers, or who? Mr. Gibbs, Miss Rivers?
I just have inmates, Judge.
Who?
I just have inmates, Judge.
Miss?
That's
Your Honor, I
Yeah,
have a couple out of custody.
okay, let's do them.
All right. Your Honor, the first one is not on the docket. I'd asked her to come. It's Charlotte Prattley, 23 CF 143. Your Honor, she was set for 6/26. She failed to appear. She's always made her court dates in the past, her appointments. She immediately contacted our office. She thought that the July trial date was her next court date. So I told her if she showed up today, I would ask the court if you would consider withdrawing the capias. I don't object, Your Honor.
All right, we'll withdraw the capias. So what is her next court date?
Be 8/28.
August 28th, okay? Make sure you get with Miss Rivers to make sure you understand, okay? All right, thank you. Withdraw
you,
the
Your Honor.
capias.
All right, you're good. Your Honor, the next one I have is Michael Owen, 19 CF 2090.
Yep.
Your Honor, he is requesting a continuance in this matter. I had spoken with the state. She had wanted to set it for a control date for next week because we're trying to get him into rehab. He is unable to appear on that date because his fiancee has medical.
Right. The medical issues that I discussed with you before, she has an appointment on the 6th, and that's the day they wanted to do it. So I was wondering if I could push it off a little bit further than that so I can get some ducks in a row.
State's ready to take this to a hearing, Judge. So if we could set this for a hearing on July 27th.
What is this, a VOP hearing?
It is,
Yes,
Your
Your
Honor.
Honor.
And you want to go beyond that?
No, the 27th is fine. She had said the 6th of July.
Oh, okay, well,
and
I
she
mean,
has
were
a
you,
appointment
hey,
that
were
day.
you as foreman on one of my juries?
Was I?
Yeah.
I don't believe so, sir.
Okay, you look just like another.
They said everybody's
All
got a
right,
doppelganger, sir.
July 27th, that'd be good.
And that'll be at 2 o'clock for a hearing
Yeah.
with subpoenas. Okay, thank you.
Okay, thank you,
wanna
sir.
come before then.
July 27th.
Thank you, Your Honor.
Okay.
Your Honor, the next case is Sixto Rivera before the court on 22 CF 1214. In his companion case, that would be 22 CF 1222. Your Honor, I have filed a motion with the court asking the court to review the prior determination of his indigent status. The court previously appointed him a public defender. He does not meet the
Mr.
statutory.
Rivera, I saw there, it looks like you're a very successful man. I thought you were disabled and didn't have anything, but you look like you're very accomplished.
Your Honor, that information is no longer valid. I don't have the 2 rentals that this woman is referring to. That information was, as she said, in February. We are about to be July. She didn't even call me. After I called 2 weeks later,
We never
she
received a
sent
phone call.
a documentation, she sent documentation requesting to withdraw. Never, not once. I didn't even know who she was until Monday that she called me here. She didn't do financial affidavit, she didn't do nothing. She just decided not to.
Okay, hang on one
Yeah.
second. Mr. Rivera, he says he doesn't have anything.
Yeah, Your Honor, we actually pulled the tax appraiser's documents showing that he has 2 different properties. I also pulled Zillow, which is still showing that he has 2 properties, and the worth of the properties is in excess of $650,000.
Goodness, you're doing good, Mr. Rivera.
And back in February, he testified in front of Judge Terrell that he was on disability income and he received $6,500 a month from the government, as well as having the $2,000 a month in rental properties. He does not, by our definition, qualify to receive public defender assistance, and the burden is actually on him to prove otherwise.
Probably doing better than your attorneys,
Yes,
you know.
yes.
You
And
you
so-
look like,
The burden is on-
Your Honor, as
the
I
burden is
stated,
on
not
him.
even
You look like you-
not even financial affidavit to actually state and the matter that my properties are worth whatever they are, I cannot do anything because the person who was determined to be the aggressor on this is my wife. And I can't do anything with those properties because that woman, which stole over $10,000 with the help of Ms. Busson over there, on property, I can't do anything. So essentially, I have nothing. I live in one of the properties, so,
He's listed as the sole owner of,
but still, on the state of Florida, I cannot do anything unless the wife does anything, even if
And-
I have a prenuptial. So ma'am, that is, doesn't even
Well,
matter.
you're making a lot of money, Mr. Rivera. You're a very successful man. I was very impressed.
And the money goes
With,
to those places.
I know, but
And that's okay. I didn't request a public defender.
I know, I thought I was going to help you. I thought I'd help you out because I thought you were disabled, but living on the street, had
I'm a
nothing.
disabled veteran, that's
But
correct.
you're intelligent, you got property, you're very successful, you're doing well. I got to let them off.
That's fine. I
And you'll have
got no
to-
issues with that.
you'll have to
But
hire-
right now, the pretrial was set for Monday,
Now we
and for last Monday, and she rescheduled that to come here and say, now I withdraw from the
August
case.
28th will be the next pretrial. then.
Over a year.
No, it's this.
Over a year of this, not a single shred of evidence has been shown.
No, but
I'm requesting to
I
show
just,
the evidence.
I just got here. I'm trying to work with you. August 28th.
How can I,
pretrial.
okay,
You can
August,
get-
July 28th, you said?
August 28th is the next pretrial. That's when you have plenty of time to get you an attorney to fight for you.
I'm not gonna get an attorney, because no civilian attorney, no private attorney wants to take the case because they don't wanna show the evidence against her. Any attorney that takes the case is gonna have to show that this woman is lying. It's gonna have to show that the police told me I was the victim and the other person was the aggressor.
There are some attorneys out there that'll be glad to go out.
No one wants to. Everybody tells me, as soon as you're done with me, Busol, then I'll do that. So,
No.
hey, that's what I'm saying.
I don't have control over their
Oh.
organization. August 28th, you're smart.
I'm
You
not
can get
getting
an attorney.
anybody, Your Honor. I'm coming by
Okay.
myself. I'm coming by myself again, and I would like to actually move this forward to the trial.
August 28th, then.
Thank you.
Pre-trial, August 28th.
Great.
Thank you.
Thank you, Your Honor. Have a great day.
Mr. Rivera, go see an attorney. Go get you an attorney.
I can, Your Honor.
Yeah.
Because although I make that money doesn't come to my pocket.
Well, yeah,
That's the case.
I tried to help you out, but I can't.
Thank you, I appreciate it.
Okay, thank you.
Judge, I've got a couple of matters I can bring up.
Let's take a little break. This coffee's got my tummy upset.
Yes, sir.
Nothing else has got me churning, just my coffee, so.
All right, please.
15.
Dave's Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at davestirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Bad Boys Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Pretch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Bad Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystilepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
Seek Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Procedural Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Fat Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Anybody have any idea if it's true?
For what?
He really is. No, right.
I know what you mean. He's got a bunch.
All rise, please. Court's back in session.
Thank you. Be seated. Yeah.
Your Honor, Ms. Flowers has two cases that are on this afternoon's docket that will only take a moment if the court wishes to address.
Okay, yeah.
Carl Menz on this afternoon's docket. We're asking to continue. I was just appointed to the case.
What was it? Carl what?
It's on the 2 o'clock docket, Your Honor. Carl Menz.
M-E-N-Z, Your Honor.
Okay, well,
Our case, we will.
we'll continue it to August 28th.
Thank you,
Is
Your Honor.
that okay?
I'm sorry,
Yes.
Your Honor, that's, August 28th is a case status, and this is a 3850, so we'll need, that'll be something, time consuming.
Oh,
Yeah.
okay. You want to go into September, like September 7th or something?
That's acceptable to the state if it is to Ms.
Is that a good
Flowers.
time?
Yes, I
About
think that
then?
would be for the best, honestly.
You probably need some time to get familiar with the 30th.
Yes, Your Honor.
Yeah. We'll try it September 7th, and if that's still not, because those 3850s tend to be very complex sometimes, and
Yes, Your Honor.
then we'll see about at any other date, but try to see if we can do it September 7th.
September 7th, okay.
Thank you, Your Honor.
Thank you, Your Honor. Also, I have, I'm covering for Mr. Harper on the Mosley case. That was also set for this afternoon, and I believe there's no objection to a continuance. Mr. Harper's in trial today.
That's correct, Your Honor. Mr. Harper did let me know he'd be in trial today, so we have no objection to that being
Okay.
continued.
What, miscellaneous or August 28th?
Your Honor, this is also a 3.850, so
Oh.
again, it's a lengthy hearing.
Why don't we try, say August 31st at this, is that too soon?
No, we should be fine on that, Your Honor. I believe Mr. Harper.
Okay, well, he can ask for some other day if that's not right, August 31st.
Thank you, Your Honor.
Thank you, Your Honor.
Okay.
Thank you. James is on. Yeah.
Thank you, Ms. Flowers.
Thank you. Thank you. Back this afternoon. We have one hearing this afternoon.
Oh, yeah, okay.
Thank you, Judge.
Judge, I've got a couple that I can call. Janice Liz Martinez. Judge, this is going to be a plea. It's a violation of probation.
Okay.
Ms. Martinez, can I mark you, okay?
So,
All right, this is 18 CF 3100, State versus Jen Liz. Is that right, Jen Liz?
Pronounce your first name for us.
Janelle's Martinez. Ms. Martinez, would you raise your right hand to be sworn? You swear the testimony you give for is course the truth, so help you God? You swear to tell the truth?
yes.
Okay. You can put your hand down. Did you read and sign this plea and sentencing agreement form?
Yes.
You want to enter an admission that you violated probation, is that correct?
Yes, sir.
Are you aware of the rights you're waiving by entering this admission? You aware of your rights you're waiving by entering?
Yes.
Has anyone forced you or threatened you to enter this admission?
No, sir.
Are you under the influence of any medication or drugs that would prevent you from knowing what you're doing here today?
No.
Are you happy with the work Mr. Williams has done for you on your case?
Yes.
Court finds the admission is freely and voluntarily entered. Court accepts it, adjudicated. And the supervision is to be modified to 18 months community control with electronic monitoring, theft offender course, 50 hours, 50 public service hours, and all original conditions are to be completed.
Your Honor, just one thing, there are costs of transportation that I need to ask for to the Sheriff's Department, $400.50.
That's the expense that they incurred in transporting you up when they brought you.
You're going to have the entire time of probation to pay it.
Yes.
You want to pay that? The court's going to impose that. Do you object?
Judge, I don't object to the amount.
All right. Anything further? You have the entire amount of time to pay that, or go to judgment. If you don't pay it, just go to judgment, okay? Thank you.
Thank you, Judge. You're going to need to meet briefly. And then they'll direct you further. Judge, I've got...
Your Honor? I'm sorry, can we address Ms. Martinez again?
Okay.
Ms. Martinez, come back up
She has
here.
actually passed her scheduled termination date, so I'm not telling, a suggestion to the court would be to revoke and start her a new 18 months.
We could do it that way, Judge.
Okay, revoke and start a new 18 months.
GPS is $1 a day,
Yes, sir.
same terms,
Yep.
and waive supervision fees.
Yes, sir.
Thank you.
Thank you, sir. Appreciate it.
Doing a good job defending these people, Mr. Barrett.
I've been doing it a long time.
They changed it instead of extending to
You need to
just start
get
new
a supplemental PD income, I guess.
I get to come to court on Monday too, by the way.
Yeah, whoever, I want y'all to know, I want all you attorneys to know, and staff, I had nothing to do with scheduling court July 3rd.
Just talking about
I don't know how. That was, usually they schedule court days. Like right now, my Jay is working with court admin, scheduling court stuff for next year this time, a year in advance. So whoever was here, I don't know how July 3rd got set, but if I had known it at all, I would not have had court July 3rd. But we got to have court July 3rd.
Your Honor, how about December 28th?
Judge, we need you to look at that, please.
We got December 28th.
Got time to fix that. December 28th.
Yeah.
That's between Christmas and New Year's.
Yeah, what is,
Miscellaneous all day.
we'll have to take a look at that.
Please.
Yes.
Thanks for bringing that up.
The state and I had talked about
Yeah.
the time before, the week or so before.
Do we have, we don't have any notices out for anybody December 28th, do we?
I think we've set one person for a competency status hearing on that date. That's how I found out.
We can,
So we can do that.
we'll see about getting that, Miss Ann, you have any objection? Okay.
Judge,
See about, I'll get my Jay to see about rescheduling that.
Judge, if you'll recall, Desiree Lige failed to appear in court day before yesterday for pretrial conferences. She's here today. I'd like to address the capias and see if I can get it withdrawn. Ms. Lige?
What's the case number? It's mine.
Don't recall off the top of my head.
Did she get her days confused?
They have changed her medication, and one of the meds is affecting her memory. And so, in fact, I'm going to probably refer her for an evaluation.
What about that, Miss Lee, Miss who?
She's mine, Judge.
Okay, I'll withdraw the capias.
Thank you, Judge. Leave her on for August 28th?
Yes.
Yes, sir, and I'll go ahead and get somebody looking at her between now and then.
We do need to get this one taken care of, Mr. Williams. It's pretty old.
Yes, ma'am. I understand. Okay, ma'am, August 28th. If you can't remember it later, call the office and we'll tell you, okay? All right. All right, Judge, that's all I have that's out of custody.
Okay, thank you.
Mr. Gibbs is lined up. Please raise your right hand.
Your Honor, Tim Gibbs on behalf of Jerry Beaver. This is 20 CF 435, 20 CF 1624. If I can have just one moment with the state.
This is, that's the lady that's called down. He gonna have 6 because so it's 26, 32. So he doesn't smoke? No.
Well, okay.
And what's the recommendation? So I'll do 11:29.
Beavers, would you please raise your right hand and be sworn? You swear the testimony you give for this court is true, so help you God?
Yes, sir, I do.
Thank you.
I spent 6 months in jail.
Would he take 11:29 jail? Does he have that kind?
Judge, I don't have a written plea written up, but we do have an agreement, Judge, that Mr. Beaver would be able to plead to 11 months, 29 days, Okaloosa County Jail with credit for 4 months stipulated in order to resolve his violation of probation. If the court prefers a written plea, I can certainly type that up.
I've swore him in already. Mr. Beavers, do you want to enter an admission to violation of probation?
Yes, sir, I do.
Is you aware of the rights you're waiving by entering this admission?
Yes, sir, I do.
Has anyone forced you or threatened you to enter this admission?
No, sir.
Are you under the influence of any medication or drugs that would prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Gibbs has done for you on your case?
Immensely.
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 It's doing good. That's probably better than an absolutely. Who got the absolutely? Mr. Nopes? Okay, yeah, you got an immensely. Okay, good.
I'll work on it, Judge.
He's doing great.
All right. Okay, court finds the admissions freely and voluntarily entered. Court accepts it, sentences you to 11 months, 29 days, county jail, credit for 4 months.
4 months stipulated, Judge.
Stipulated 4 months credit. So was there anything else?
I think that's it. Revoke and terminate, 1129, 4 months stipulated
Revoke and
credit.
terminate probation,
Concurrent, yes.
Concurrent.
Thank you.
Everything concurrent.
Concurrent. Everything's concurrent.
Thank you, sir.
Thank you, Judge.
Okay, thank you.
Outstanding money to collections, Judge?
Yes, sir.
The money?
Any of the money that was charged, it'll go to collections.
Okay.
Mr. Gibbs, could you please, the score sheet?
Judge, if I can approach with the score sheet, that ultimately was a downward departure.
All right.
Your Honor, Tim Gibbs on behalf of David Fiducia. This is 21 CF 667, 21 CF 1433. Spoke with the state. I think we have a resolution from
Okay.
No, I don't remember. What was it? Yes, Your Honor. Apparently, in this case, there was an addendum to the violation report. However, for a crime that he had committed prior to him pleading, admitting the prior violation. So I do not believe he's in violation of the terms.
He's not, so you're going to
I
dismiss
don't believe, I request to dismiss the VOP and reinstate if he, the probation.
And Judge, we of course would accept that to dismiss the VOP to reinstate to probation. He's already been accepted to Phoenix House. We've contacted them. And if we dismiss the VOP today, he will be on their wait list to wait for them to come pick him up to take him to their program.
All right, we'll do that. Okay, dismissed, and then go into Phoenix House. Okay, good luck to you.
Thank you, sir.
Thank you.
Good luck. Thank you. Your Honor, Tim Gibbs on behalf of Jesse Gainey. This is 22 CF 401, 22 CF 402, 22 CF 2929. Judge, we'd like to enter denial today, and if we could set this for July 27th without subpoenas.
Okay, July 27th. Thank you.
Your Honor, I don't mean to interrupt, but Mr. Fiducia will be going bars to bed, is that correct? To Keaton?
Yes,
To
sir.
Phoenix House.
Yes.
I'm sorry, to Phoenix.
Phoenix House,
Yes, sir.
yes.
Phoenix House, you need.
You can ask the probation out of everybody. I was sitting there.
I hope he makes it. He's not.
Okay, next, July 27th. Thank you.
Oh, I've got that one. We'll take care of it. Your Honor, Tim Gibbs on behalf of Jared Atkinson. Judge, this morning, I believe he's actually on this afternoon. Well, he's actually on this afternoon's docket for 23 CF 1179, which is a new law violation. Judge, he's already set for next week on the 6th for a VOP arraignment on 22 CF 1394. I'd like to simply track those together for now. I'll likely also be filing for a bond hearing to have that day as well.
Okay, we'll do it that day then. Thank you.
Your Honor, may I address the court?
I don't recommend it. Please don't talk about the facts of your case.
No, it's not about this case. It's kind of, due to a conflict of interest, when I was sentenced on my VOP case with Miss Lisa Rivers, she was my prosecutor, but was released from my case a couple years before that due to a conflict of interest. I didn't know she was my prosecutor. Nothing personal against Miss Rivers. She's a good attorney. But I'm asking that he file a motion to dismiss that case based on illegal procedure, malicious prosecution.
Like I said, we talked about that all.
You have to talk to your attorney about all that. It's not before the court today. I don't know if I can consider it. If I can, I'd be happy to consider whatever it is you're asking for. Okay? But it has to be properly filed and noticed to the state so they have an opportunity to respond. Okay?
I'm also willing to take a plea today if the state is in agreement of my granny's sick. She's the only one I ever had. And to suspend the 44 months offer and reinstate probation of maybe up 5 years of state probation. I would do that with exception of some rehab.
Well, I'll tell you what, we'll put you back in the holding cell and let your attorney have a chance to talk to the state. And if they can work it out, I'll be happy to take a plea today.
Yes, sir.
Okay?
Thank you.
If they can't, then I won't.
All right.
Okay, thank you. Just hold on to him. Just hold on to him.
That's all you got? Okay.
Is it Roberts? Rodriguez?
So, Your Honor, she has actually 3 cases. One, though, has not been arraigned yet, except for 7-6. So at this time, we would ask to put 21 CF 2171, 22 CF 1611 with the one that's set for arraignment on the 7-6.
Okay, 7, put them all on July 6th.
Good morning, sir.
Morning. All right, so you're going to need to sign it right there. Your Honor, I had gone over the terms of the state's offer and everything with him the other day at the jail. I just not typed up the agreement.
Mr. Simons, would you please raise your right hand to be sworn. You swear the testimony you give for his court's the truth, so help you God? Okay. All right, you want to enter a plea of no contest to 1 count of possession of a controlled substance, a third-degree felony, in 23 CF 1316. Is that correct? You want to enter a no contest plea to those
Yes, sir.
charges? Did you read and sign this plea and sentencing agreement form?
We went over it the other day, sir.
Okay. You have any questions
No,
about
sir.
it? You understand the rights you're waiving by entering this plea?
Yes, sir.
Has anyone forced you or threatened you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that would prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Rivers done for you on your case?
Yes, sir. Absolutely.
Okay. So that wasn't quite an imminently, I think, but it was an absolutely. I think that was good. Court finds the plea is freely and voluntarily entered. Court accepts it. Judge you guilty. Sentence you to credit for time served. 515 court costs, $100 cost of prosecution, $150 PD fee. So I guess you'll be getting out today.
Yes, sir.
Stay out of trouble.
Amen. I'm going to go to rehab Monday.
All right, the drugs, just, you see what problems they cause.
Yes, sir. I'm going to go down to Panama City to the rehabilitation center.
All right, well, good. Good luck to you.
Mr. Gibbs,
Thank
we'll
you.
worry about you.
Go to you.
Oh, no, you go. You go to him. Your Honor, I just need a moment with her.
This Miss Simons? Oh, Steinman? Okay.
To reinstate probation since all my fines are paid.
Your Honor, she's indicated that she wishes to plead straight up to the court.
Your Honor, can we set this next week for a sentencing hearing so the state can make a presentation?
Okay.
The court?
You want to, all right, what's she pleading to?
Your Honor, it's a violation of probation,
Okay.
and she is asking if the court would do that sentencing today.
No, I got to give the state a chance to put on their side. I'll do it, what day did you suggest, Ms. Glisson?
How about the 6th?
July 6th? Okay.
Not giving you a choice. Yeah. Not from her, no. You have to please straight up to him. Or take her offer. And her offer 6 months. 180. You want to go ahead and enter the plea today?
For 180 days?
No, to plea straight up to the court.
Yes.
Okay, so I have to hand it to him. He's going to ask you questions.
All right, you are, is it Dorinda?
Dorinda, yes, sir.
Dorinda Steinman,
Yes.
22 CF 1071. Would you please raise your right hand and be sworn? You swear the testimony you give for this court is the truth, so help you God.
Yes.
You want to enter a admission that you have violated probation, is that correct?
Yes.
Did you read and sign this plea in sentencing agreement form?
Yes.
Are you understand the rights you're waiving by entering this admission?
Yes.
Has anyone forced you or threatened you to enter this admission?
No.
Are you under the influence of any medication or drugs that prevents you from knowing what you're doing here
No.
today? Are you happy with the work Ms. Rivers has done for you on your case?
No.
No?
No, I have a 77-year-old man that I care for and 3 children and 2 puppies, and this is my first violation. All my fines are paid.
Hang on 1 second. Are you happy with the work Ms. Rivers has done for you on your case?
I mean, I guess, I don't, this is not the outcome that I had wanted for today, no.
Well, I mean, the attorneys don't have any real control over the outcome. The state can agree to something. What is your complaint about? You have a complaint with Ms. Rivers' representation?
No, I guess not.
You don't? So you're happy with the work she's done for you on your case?
Yes, yes.
Okay. Court finds the plea is freely and voluntarily entered. Court accepts it. We'll set the state, you're asking that you want the sentencing not to be now, but July 6th, is that correct? Okay. Well, the state wants to put on something. I don't know what it is.
Your Honor, we do have July 3rd. She's wanting to know if the court would consider July 3rd. That would still give the state time.
We've got a stacked docket. Miss Glisson says she needs till July 6th, so thank you. Okay. Webb. All right, good morning, Mr. Webb.
Morning.
Your Honor, he is before the court for arraignment on his violation of probation on 22 CF 2054. We're going to enter a denial at this time, and if we could get a new date.
All right. What about July 27th?
Okay, Your Honor. Thank you, Your Honor.
Thank you.
I mean, is that what we're going to?
I'll be back out. But I just got it from her. Yeah.
Back out to the jail? Have you got a card?
Not on
No,
me.
okay, that's right. Am I done?
Yeah.
All right, thank you.
Your Honor, this is Mr. Whitman. He's listed on the docket as Sonchai Whitman, and he says that's his twin brother, that his name is actually Suchat Whitman. So he did want to inform the court of that. I am going to ask that this matter be continued to 7/6. This Florida State Hospital has found that they sent him back. He's been in for 5 years, and they said he's just not restorable. But there is no place for him to go, no place for him to live. I've been working with Mr. Barnes on this, and so I'm asking the court to continue it to 7/6 to give an opportunity for Mr. Barnes to find a place for him to go when he gets out. He has no money, no place to live.
Lisa, what's the case number?
17, say it again. Seventeen CF 3017. Thank you.
So, I mean, what's he being held on? I mean, is he?
Well, Your Honor, there has to be a finding with the court as to his status. But I didn't want to do it today because of the fact that there is no housing for him.
All right, July, what did you say, July 6th?
Yes, Your Honor.
All right.
Because on that date, I'll be asking under Rule 3.213 for the court to dismiss the case because he's remained incompetent continuously and uninterrupted for 5 years. He's been at Florida State Hospital. He comes back, he goes right back to Florida State Hospital for the past 5 years. And at this point, I'm just trying to find a place to live.
We'll take Ms. Glisson,
That's fine, Judge. We can leave it on the.
July 6th.
When it came back.
I didn't see that.
July 6th, we'll see what we can do.
Yes, sir. So you're going to come back to court next week? Okay, so we can they're trying to find you a place to live. Okay? Yes. Your Honor, we had Jody Yawn put on today for status. It was set for court last time, and it was set for status then. He's at Florida State Hospital, and we've received no information about him and what is going on with him. I contacted various people that were listed on the order to try to get updated information on Mr. Yawn, and the attorney of record for DCF, that came back. The people that were listed in the order, they said they no longer work there. So I had spoken to Mr. Barnes about seeing if he could help me find someone to get in touch with at Florida State Hospital because they were supposed to have presented a report, a 6-month report, and have not.
What day do you need to get that accomplished?
Your Honor, if we could have this set for 7/6.
Okay, July 6th.
Thank you. And Your Honor, the state did want me to go ahead and address one for this afternoon. She's in jail, but she wouldn't need to be brought over. Are they already here? Correct, doesn't need to be brought over. That's Tina Warrington, 23 CF 1139. We would request to put this at the end of the month.
Objection.
July 27th?
Thank you, Your Honor.
Okay.
Will that be with a waiver of speedy trial?
Huh?
With a waiver of speedy trial?
Yes, it would be with the waiver of speedy trial.
Your Honor, we're recalling Mr. Jared Atkinson. This is 23 CF 1179. Judge, we'd like to just leave this set for next Thursday, the 6th. He's got a VOP arraignment. We'll leave him that morning, Judge.
All right, thank you, sir.
Mr. Miller.
Actually, Judge, if I may, I do have one other on the docket for this morning. Michael Bullaboy, 21 CF 2621, 21 CF 2633. Judge, we have a stipulation with the state to continue this to July 27th. That would be with subpoenas.
That's correct.
All right, July 27th.
Thank you, Judge.
Charles Russell, Public Defender's Office. Judge, this is Larry Miller. His case number is 20 CF 2060. We're here on a motion to reinstate his bond and pretrial services. Mr. Miller was released back in September of 2020 on this case on a $20,000 cash professional bond with pretrial supervision. On or about June the 8th of this year, the court entered an order revoking his bond and commanding arrest based on an affidavit filed by the pretrial services officer, Ms. LaQuay, and she's present in the courtroom. In talking to Ms. LaQuay, the concern that pretrial supervision had is that one of the conditions of pretrial supervision was that Mr. Miller not go where minors congregate, and I believe there was some misunderstanding about exactly what that meant. Clearly, he can't go to Chuck E. Cheese or the skating rink, but apparently he went to a youth baseball game because his grandson was playing, and that's why the pretrial services filed an affidavit in a violation. Mr. Miller's understanding was that he thought he could go to this baseball game as long as there were other adults there, and there were. In fact, there was a young child seated next to him in the video that pretrial services got, but they weren't concerned about that because they said it was obviously there were other adults around supervising him. But pretrial services was concerned, like I said, because he was at a youth baseball game. I think it was a T-ball game, maybe a Coach Fitch game. So what we're asking for today is for the court to clarify, don't go where minors congregate, because does that mean he can't go to the beach or to Walmart or whatever? And also ask that the court reinstate his bond and reinstate the original pretrial services supervision.
State.
Your Honor, the state is opposed to the reinstatement. I do have Ms. LaQuay here, and I'd like to inquire to her as to whether or not there is a reasonable belief that there was a misunderstanding. So if I could go ahead and ask that she be put under oath.
You want to come on up here? Quinn, would you please raise your right hand and be sworn? You swear the testimony you give before this court is the truth, so help you God?
I do.
All right, have a seat.
Ms. LaQuay, would you state your full name, please?
Officer Tiffany LaQuay with Okaloosa County Pretrial Services.
And ma'am, in your capacity as an officer with a pretrial services, have you had an opportunity to supervise Mr. Larry Miller?
Yes.
And did you have an opportunity to instruct him on the terms and conditions that applied to his supervision?
Yes.
And did you specifically instruct him as to a condition that required that he not be where minors congregate?
Yes.
Did it appear that he understood that?
Yes.
Could you give us an example of why you believe that he understood that and how he was instructed?
So the specific example that I discussed with him in reference to not going where minors congregate was when he inquired about going to church. And so we discussed with him that he could go to church. He was given permission to do so, but to not be where minors congregate, to include he could not go to the daycare area or the playground area located at the church.
And so in your opinion, as his supervising officer, would a youth ball game be where minors congregate?
Yes.
And is that a concern then?
Yes.
Do you have concerns for the safety of children because he might actually end up being unsupervised in those circumstances? In other words, he might be with a child when there was nobody else around.
If he was around children where there were not other adults present, then yes.
Thank you. I have nothing further for Ms. LaQuay. Mr. Russell.
Mr. Russell.
Thank you, Judge. Ms. LaQuay, in the particular video that you based your affidavit of violation on, were there plenty of adults around?
Yes.
And in fact, in your affidavit, you indicated that you were not concerned about the little boy that was seated next to Mr. Miller because there were obviously plenty of adults around.
Correct. That was not the cause for the violation.
Okay. Do you specifically recall any discussions with Mr. Miller about Walmart or the beach or the movies, anything like that?
I can't honestly say that I recall any specific conversations other than the one in reference to the church.
Okay. What discussions, if any, did y'all have about his own grandchildren?
I don't believe we've had any discussions other than he had to ensure that he had another adult present in the event that he was with any minors.
And Mr. Miller has been on pretrial supervision since approximately September of 2020?
Correct.
So almost 3 years?
Yes.
And this is his first violation?
Yes.
Okay. That's all my questions, Judge.
Okay, thank you.
Thank you, ma'am. Your Honor, the state has no further witnesses, just argument.
All right, go ahead.
Your Honor, the state does still oppose Mr. Miller being reinstated to his probation. We do feel that that was a willful violation. It's clear that children congregate at youth T-ball games. And the reason for that, Your Honor, it's not, this is specifically, there are two separate conditions. One is shall not be unsupervised with minors, and one is shall not be where children congregate. Because there's always an opportunity, if there's children around, that a defendant can slip off alone with a child. It's very easy. They could have gone behind a dugout. They could have gone behind the snack bar, otherwise where there's no adults. Any time where the children congregate, there's an opportunity for a defendant to slip away. That's why that is a separate and distinct condition, and that's why we do believe that Mr. Miller was instructed, do not be where children congregate, and that he did willfully violate that condition. And we still have concerns about him being around children.
Judge, may I respond?
Yes.
Actually, Mr. Miller had two cases. The other case we had a trial on in November. It was a capital sexual battery case that he was found not guilty on, and he was released on a cash professional bond, pretrial services for both of these cases. This case that's still left is, we were trying to set it for trial, and as I indicated, the child in the video is his grandson. The mother of that child is present in the courtroom, and she indicated to me, and she's prepared to testify if the court wants to hear from her, that that was their understanding that he could go to these games as long as there were adults around, and she can testify that since he's been released, they've religiously followed that restriction, that he's never, if there's kids around, he's never by himself. There's also an adult nearby. So the concern that the state has is that he will slip off and be with a child. I don't think that's going to happen because, as I've indicated, he's been able to do it for 3 years.
All right, well, anything else?
Your Honor, we would make the court aware that part of the basis for us continuing the trial this time is because another victim has come forward, so we anticipate that also being before the court at some point, but that's not a basis for the violation right now.
Well, I mean, that's kind of an ambiguous thing where children congregate. What's a child? Is that younger than 18?
Yes, Your Honor. A minor. And it specifically says where children congregate, and it gives the examples, so.
There's all kind of, so many various, what if he's at the beach, no one's there, but kids congregate at the beach, but there's no one there? It's kind of, I'm going to say this. I'm going to reinstate it, but you can't be around any kids, children, unless there's other adults present. Okay? So.
Your Honor, so he will be allowed to go to children's T-ball games and school
If
functions,
there's other
that type of thing?
adults present, yes.
Your Honor, the state still has concerns for the safety of those children.
Well, you know, if he goes to church, there might be someone, he may be sitting there and some people come in late with 2 or 3 kids and sit right in front of him or next to him. What's he, I mean, kids congregate in church. I mean, if he's at college basketball game out here, well, is he supposed to interview 1,000 people to see if they're under 18 or not? I mean, you know, it's just, how can he?
There are obvious places, Your Honor, like a children's T-ball game is
Yeah,
kind
but
of
a
obvious.
children T-ball game, children T-ball, everyone I've ever seen, there ain't a bunch of kids out there with no parents there. They're all there, it's loaded up with parents. So, I mean, I don't guess he's been convicted. I mean, that's what I'm ordering.
Yes, sir.
And you know what I'm talking about, right? Is Mr. Miller? You know what I'm talking about, right?
Yes, sir.
If you mess up, I'm gonna revoke your bond. You're gonna be no bond. Okay? But if there's parents around, adults around, and you're watching some game or something, you know, Okay. But I'm trying to think of a situation where there would be no adults around, there'd just be kids. I'm trying to think of where that would be.
I mean, Your Honor.
Where would that be? Where
Your Honor,
there's
it
just a
does
bunch of-
specifically list daycare centers, it specifically lists, convenience stores. That's actually listed in the guidelines for those specific rules. So there are situations
Those
that
are
the
guidelines,
legislature.
right? I mean, what if he's in the junior food store paying for his gasoline, and here comes 5 kids jump out of a pickup truck, come in there? I mean, if there's adults around, there's no violation. If there's just a bunch of kids, there's no adults, then you understand? That's what I'm changing it to. Thank you.
Mr. Weiser?
Charles Russell, Public Defender's Office. Judge, this is David Weisar. Case numbers are 21 CF 1739 and 21 CF 1740. Mr. Weisar had filed a motion for Nelson hearing back on June the 1st, and we set it for a hearing, and it's a Nelson hearing in both cases.
All right, Mr. Weisar, would you raise your right hand to be sworn? You swear the testimony you give before this court is the truth, so help you God?
Yes, sir, I do.
What is the problem you have with Mr. Russell?
This is my 5th Nelson hearing, sir, and it stems back from almost 2 years. Anything that I ask of him, I have to take this procedure to be, to get my discovery, to get my point sheet. He was ordered by Judge Terrell 6 months ago to get my phone. I got all the paperwork right here. I've asked him to file several motions on my behalf. Nothing's been done. I filed my own motions. I got copies of memorandums from the courts. Nothing's been adopted. Nothing's being done. I've asked for deposition on Lieutenant Rader, Officer Dollar, and Ms. Beck from Probation Office. None of that's done.
What charges are you facing?
A failure to register, Judge, and then the other case is corruption by threat against a public servant, resisting without violence, possession of paraphernalia.
And is he set for trial?
No, sir. What had happened is when we came in Monday, Mr. Weiser has a cell phone that was taken into evidence by the Sheriff's Department in a different case. We finally figured out where it was. The ultimate plan now is I'm going to file a motion with the court to see if we can get that phone released. Mr. Weiser claims there's information on that phone that will be helpful in his case, and Judge Terrell didn't actually order us to take the phone. We don't care about the phone. We care what's on the phone, and so we're working on that.
What about these other things that he says he always has to ask you to do stuff?
Okay, so discovery was provided to him by the previous public defender, but we provided him another copy. We've also provided him a copy of all the deposition transcripts, so that's taken care of. He wants me to depose Lieutenant Rader. We've already deposed him. Deputy Dollar, he wants us to depose him. We've already deposed him. His probation officer, he wants us to depose. I don't see that her information is relevant, so we have not deposed her.
All right, well, yes, sir, Mr. Weiser.
My probation officer on the failure to register is the one that told me to go to this address on June 10th. On the 11th, these individuals raided my motel room for failure to register, not even 9 hours out I was there. And she claims that she had no contact with me till the 14th, which would put me in violation of the registry, which is not true. She's the one that told me to go there. They logged my GPS into there.
Well, Mr. Russell, are you going to take the probation officer's deposition?
I can, Judge. I don't see that she has information relevant. What Mr. Weiser is saying as far as he was told to move from the Holiday Inn to the Comfort Inn, there's nobody disputing that. They told him to move, and so he did. The problem is that after he moved to the Comfort Inn, within 48 hours, that new address information was not provided, I think it's to the driver's license people and or the Sheriff's Department as required by law. So I understand what he's saying about her telling him to move.
It sounds like Mr. Wise or Mr. Russell is checking into things. You may want to consider taking that deposition of that probation officer. There may be something that she hasn't, if she's under oath, that she might, I'd go ahead and take her deposition. I'm not telling you how to do your case, of course, but Mr. Weiser is concerned that she may have some information that could help his case. So, Mr. Weiser, it sounds like Mr. Russell's or some other public defender's done everything that you've asked. They've taken depositions, they've given you discovery. He's going to take the deposition of the probation officer. So I find he's not ineffective at this time, okay?
Can I represent myself, sir? I'd like to try to represent myself because the motions I filed, he won't even adopt my motions.
Because you're represented by an attorney. So at this time, he's not ineffective. You see if he can work and see what that probation officer says, and then if you feel like you want some other Nelson hearing, we'll take a look at it.
It's my 5th time, sir. Is there any way I can represent myself, please?
Not in front of me, it's not been 5 times.
No, it hasn't.
I'm very easygoing.
I understand.
I try to work with people charged with crimes. I've been a prosecutor and a defense attorney very, very, very long time, 40-something, 30, 43 years, and judge. It sounds like he's doing what he's supposed to at this time, but I'll consider, if you feel that he's not doing it at some other time, let's see what he says. He says he's going to take a deposition of probation. Let's see what that says. You see what that says, and then we'll consider if you. I'm not going to let people just fire their attorneys just because they feel like it.
I understand, thirdly.
And filing your own motions when you got an attorney, the court's not allowed to consider.
Okay, I totally understand that, sir. But what I'm saying is when I asked him to file these motions on my behalf, he refuses to do it, so I filed myself.
Well, he'll look at them, and if he's decided he doesn't want to, then, it's probably in your best interest. But I can't look at them and until, if you're represented by an attorney, but, it sounds at this point he's doing all this discovery. He's still going to take another deposition, I guess, and we'll take another look at it. I'm not going to say absolutely no, but we'll take a look at it. And
one more thing, Your Honor. There's video on my phone and there's video at the Comfort Inn, which my daughters have went and talked to these people and said they need a court order to release this video that shows that on the 11th that they raided my motel room for failure to register 9 hours after I moved. They didn't even give me 48 hours to register.
Well, Mr. Russell says he's very interested in what's on that phone. So he'll find it out. They're not going to give your daughter anything, but Mr. Russell knows what to do to get that information.
Yes, sir.
Okay, thank you. I appreciate it.
Thank you.
Okay, thank you.
Judge, I've got one that I missed that's out of custody. Devin Miller was on your docket. He was set over from pretrial conferences day before yesterday. This is going to be a plea.
All right. Mr. Miller, would you please raise your right hand and be sworn? You swear the testimony you give before this court is true, so help you God? You do?
Yes, sir.
Okay, thank you.
Looks like we will need for you.
And this is 22 CF 1953, State of Florida versus Devin Miller. Mr. Miller, you want to enter a no contest plea to the charge of possession with intent to sell cannabis, a third-degree felony, and possession of paraphernalia, first-degree misdemeanor. Okay, so that's what you want to do, enter no contest plea to those charges?
Yes, sir.
Okay. You got to speak out loud because it's recorded. Okay. Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Has anyone forced you or threatened you to enter this plea?
No,
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Williams did for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. On count one, adjudication is withheld. 18 months probation, cost of supervision waived, $515 court costs, $100 cost of prosecution, $50 PD application fee, $100 PD fee. No controlled substance without a prescription. Random UAs, have a substance abuse evaluation, and
Treatment, Judge.
treatment as recommended. Do not knowingly be where illegal controlled substances are kept, sold, stored, or used. Have a curfew from 10 p.m. to 6 a.m., which may be adjusted by probation to accommodate your work hours. And on count 2, you're judged guilty and sentenced to time served. Okay? All right.
And Judge, I went over a score sheet with him that's 16.40 total sentence points. We have no objection.
Okay. All right, thank you, sir. So,
thank you, Judge.
Crash landing. All right, Mr. Halstead, okay?
Judge, give me just 1 second. I had tasked my investigator to check on something yesterday when I was at the jail with him. I just want to see if I've got a response back on that yet. It was having to do with the credit. Judge, when is our next date? He's got some out-of-county credit that I want to make sure he gets. When is our next possible date to bring him back in?
Well, a miscellaneous day, July 6th.
Okay. Judge, I anticipate we would have that. It is from another county in Florida. It would be for plea, Judge.
July 3rd.
Judge, I don't know what...
July 6th.
July 6th, Judge. Thank you. All right, we'll bring you back on July 6th. We should have that confirmation on your credit by then. We don't have it yet. Madam Prosecutor, did you have a straight time offer for Mr. Hughes?
The offer that I have in the file for the VOP will be to revoke and terminate a new term of supervision, 1 year community control, followed by...
I have that, and I've gone over that with him. He asked me to inquire if the court would have a straight time.
Oh, okay, I apologize, I didn't get that. One second. I'll ask for 1129 jail.
Okay. Does that sound like what you want to do? You would be entitled to credit. Okay. Judge, if we can pass him for just a couple of, maybe bring him back this afternoon.
Okay.
I'll have a plea agreement typed up for him.
All right, till this afternoon.
Yeah, it'd be 1129.
And then it should have it.
Okay, okay, the clerk actually would calculate that.
And I'll just find out this afternoon.
Yes. All righty. Judge, we have a negotiated plea on Mr. Ledoux's case. Would be yours. Judge, Mr. Ledoux, the only remaining probation for him is a reckless driving, so there's no score sheet.
All right, you are Jeff Ledoux?
Yes, sir.
All right, would you please raise your right hand to be sworn? You swear the testimony you give for this court is true, so help you God?
Yes, sir.
Okay, this is 21 CF 1829, State versus Jeff A. Ledoux. Mr. Ledoux, did you read and sign, let me ask you this. You want to enter a no contest plea to the charge of, you want to enter a admission. Is it a VOP?
It's an admission, it's a violation of probation on a second offense, reckless driving, statutory maximum of 6 months county jail and $1,000
Right, so
fine.
That's what you want to admit, that you violated probation on this misdemeanor?
Yes.
I mean, yes. Is that correct, Mr. Williams, misdemeanor?
That's correct, Judge, it's a misdemeanor.
Did
It
you read-
exists between a second and a first.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
You understand the rights you're waiving by entering this admission?
Yes, sir.
Has anyone forced you or threatened you to enter this admission?
No, sir.
Are you happy with the work Mr. Williams has done for you on your case?
Yes, sir.
Court finds the admission is freely and voluntarily entered. Court accepts it, judge you guilty, revoke and terminate probation, sends you to time served in the county jail, $50 cost of prosecution, $50 PD app fee, $50 PD fee, and any outstanding monetary conditions to collections, and adjudicated. So time served.
Thank you, Judge. Yes, sir.
Get out today, I guess, unless you have some other hold on you.
No, sir.
Okay, very
Thanks, sir.
good. Stay out of trouble.
Yes, sir.
Ms. Lewis.
Sorry about that. Crash land.
Judge,
Yes.
we had negotiated Ms. Lewis, I think, was reset from last week, and Ms. Lewis, you were wanting to be heard on the question of your bond today.
Yes.
Judge, otherwise, I think we set you for trial, isn't that right?
Yes. I had a no bond on an FTA that I went to court on. I've been in jail for 65 days. Your Honor.
Judge Oberleisen was covering in this division when she came up on the failure to appear. She had been in court that morning. I advised the judge that I had seen her. We had broken for lunch, and she did not return for lunch. She picked up a new law violation is how she came back to court, and that's the matter that's being set for jury selection. Actually, I guess both of them are being set for jury selection.
We're here for my bond because there's a no bond on an FTA that I went to court on. And I've been in jail for 65 days, Your Honor.
You don't have a bond notice of hearing for
It's today.
I brought it up when we were in court, and I think that's how it wound up for today. She was asking for the bond, and we were in court on the 26th. I brought up that she was wanting to have a bond hearing on it and asked that she be set on the date.
Yeah, I remember that. We talked about, she was trying to argue a bond then. I said, no, we'll have it. The state needs time to see what it, we'll have it today. 29th.
Yes, sir.
Okay.
So,
You want
the
to?
state going to proceed on that? On the FDA, she says she was in court. I mean, if you are, fine. If not, that might take care of that FTA part of it.
Your Honor, I don't believe the only reason she's being held on no bond is because of an FTA. I believe her bond was revoked when she was picked up on the FTA, that she also picked up a new law offense.
What's the new law offense?
It's another drug charge, Judge.
Is there a bond on that?
Yes.
Yes, Judge, but there's a bond on that charge. And that's, the two cases are traveling together, and I think we've got them both set for docket.
What's her offense that
There's another drug charge.
what kind of, what felony? Third degree?
Third degree felonies, Your Honor. When she was picked up on the FTA after pretrial, or 2 days, 3 days after pretrial, she was picked up on more drug counts, and she was originally out on bond on possession of methamphetamine with intent to sell, manufacture, deliver, where she admitted to injecting others with narcotics.
No, she did not. I don't even know what you're talking about on that. There's no way, shape, or form. I'm taking that.
Hang on a second. Hang on a second. Whatever she was charged with, she was out on bond, correct?
She was, Your Honor.
And then, did she pick up a new offense and was given a bond, and then also picked up on the FTA?
No, Judge, she She came to court. She wasn't still present and I met with her. She was not still present when her case was called. I told Judge Oberleisen that I had seen her that morning and that I didn't know why she wasn't responding. Judge Oberleisen issued a failure to a bond revocation because she wasn't in court when her case was called, even though she'd been in court earlier that day. Apparently, they went to pick her up on the failure to appear warrant, or there was a traffic stop. I don't recall off the top of my head. But that's where the other drug offenses came into play. And so my recollection is that she already had a bond revocation at that point. I think what the state's trying to argue is that revoked her bond. And so we're trying to get her back out on bond.
Yes, Your Honor. So when she FTA'd on the first case, she was picked up and was arrested for more drug charges for which she admitted to possessing the drugs. And I had noted that the original charges she was out on bond, the 2022 case, sell, manufacture, and deliver, that's a case where law enforcement went to a drug overdose at the house she was at. A search warrant was executed, and the search of the vehicle, there was 31 grams of meth liquid located in a vehicle, and the defendant stated the liquid was water to which she used to assist in the injection of narcotics. So although this defendant was out for an FTA, even if there was there's miscommunication, the bond was revoked. It's my understanding the bond was revoked when she picked up this new offense on the original case where the drug overdose occurred.
My bondsman didn't even revoke my bond. I had talked to my bondsman that day, and because I called to give her my new phone number because I just changed my phone number to give it to her that day, and I called my public defender's office, and I talked to his secretary, and they told me to come to court the very next day. They were going to fix all this. I was already out on bond, and I'm fighting these charges. I'm not guilty. I'm innocent to proven guilty, and I'm taking this to trial. So I've been sitting in jail for 65 days on FTA I was in court on, Your Honor. I'm just asking to have my bond, whatever the FTA, no longer not a bond, so I can bond out on my charges and go home and fight these charges. This is, you know what I mean? I've been in jail for 65 days.
And I'll leave it in the discretion of the court, Your Honor.
On the failure to appear, I'll set a $5,000 signature.
Yes, sir.
And reinstate the bonds. And if you mess up, I'm going to revoke them all and make you sit in jail till we get to whatever, trial, plea. Okay?
Thank you, Your Honor.
Thank you, Your Honor.
Are we putting this on for 8/28?
Thank you.
Ma'am, come on back real quick. The question was just posed if we were putting this on for 8/28. That's fine with me. She provided us with the name of a potential witness on one of the cases. I've tasked my investigator with locating that individual and getting some information from them before we do a reciprocal on it. That has not yet occurred, so I would not be ready on that case. I believe that was the original case, correct, ma'am?
Mm-hmm. Yes.
Okay. On the new law case, I know that you want to go to trial on it, but do you?
I want to go to trial on the original charge.
Okay.
That I got last year, the one that I've been fighting for a year.
Since you've gotten your bond reinstated,
Mm-hmm.
okay. What I'm going to do is, since we have not had contact with that individual as yet, I'm going to go ahead and ask to continue both of the cases until August 28th.
Okay. Well,
Okay.
since I'm bonding out, I can go get that and bring it to you.
Okay, August 28th, and
thank you, Judge.
do the
Thank
best
you.
you can. Okay, thank you.
Hey, Beard. Come on out. Judge, this is a violation of probation. It occurred very shortly after he entered his plea. He had previously been determined to be incompetent. He was competent when he entered his plea, but looking at the facts, he may have decompensated shortly afterwards. I want to cover my bases, have him evaluated again. We'll do that internally. And so I'm going to ask that we pass the case until the next VOP date.
Okay, what date is
I'm going
that?
to do August 10th.
August 10th is fine with me. We should have it back by then.
Okay, August 10th. Thank you, sir.
Thank you.
Thank you.
McIntosh.
Hey, Mr. McIntyre.
Put your glasses on, Mr. Williams, so we can speed this up.
I'm sorry, Judge. Judge, on Mr. McIntosh's case, I'm going to Judge, I'm going to ask to pass this again. I want to try to negotiate a resolution with it. I talked with him
What
about potential setting it for trial.
July 6th.
I'm sorry, Judge?
July 6th, miscellaneous?
Judge, I can try to get it done by then.
Okay. Thank you.
Thank you, Judge.
McCoskey.
My bad.
Yes, sir.
Yeah.
And then you turn this judge.
How you doing, sir?
How you doing?
Good, that's good, sir.
Judge, the plea offer in this case involves Phoenix House. I've tasked my investigator with trying to get him pre-screened for that. That's not taken place yet. It may be that we'll have an answer for him as quick as July 6th. I just don't know for sure.
We'll bring back July 6th, see if we can get it done for him.
Thank you, Judge. This is the first time up on it. Okay. Go ahead, sir.
Come on out. Stand up and turn this judge for a second.
Sorry, I'm looking at it wrong. I'm sorry, go ahead.
I was going to say, is there any way we can get phone count over?
Madam Prosecutor, I went over with the plea agreement with him. He's asked me to counteroffer 60 days to you.
No.
Judge, we're going to go ahead and accept the state's offer of 90 days. Now, there was some discussion also about count 3. You were going to amend that?
Yeah, Your Honor, count 3, state's going to orally amend it to reflect 324.022. It's failure to have required insurance coverage. I believe it's currently failure to not have a tag is the statute. So it's second-degree misdemeanors, what he's going to plead to on count 3. It's correct on the score sheet.
And Judge, I'm indicating on the plea agreement, I've done it up as an alternative, and I'm indicating on the plea agreement that it's a plea as amended.
Mr. Moody, would you please raise your right hand and be sworn? You swear the testimony you give for this court's true, so help you God?
Yes, sir.
Okay.
All right, sir, let me get your signature right there. Right there, sir.
I'm trying.
Okay. You signed a different copy. I will. Sir, you mind if I date this for you?
No, go ahead. I can hold it.
This is 23 CF 1169 and 22 CF 541. Mr. Moody, you want to enter a no contest plea to possession of controlled substance. Is that correct, Mr. Williams? A third-degree felony
That's correct, Judge.
under 1169, and then count 2, attaching improper tag, a second-degree misdemeanor. Count 3, attaching plate not registered. Is that correct?
That's failure to have insurance.
Failure to have insurance, so
Yes,
that's the second-degree misdemeanor.
Yes, sir.
Okay.
That's correct, Judge. We have a new law violation before the court. He's set for arraignment today. We're waiving arraignments. He's entering a plea, and then we have the violation of probation.
Okay, and then in 22 CF 541, admit that you violated probation. You want to do all these things, Mr. Moody? Okay. Did you read and sign this plea and sentencing agreement form?
Yes.
You aware of the rights you're waiving by entering this plea and admission?
Yes, sir.
Has anyone forced you or threatened you to enter this plea and admission?
No, sir.
Are you under the influence of any medication or drugs that would prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Williams has done for you on your case?
Yes, sir.
Court finds the plea and admissions freely and voluntarily entered. Court accepts it. On 23 CF 1169, judge guilty, 90 days county jail with credit for time served on felony and any first-degree misdemeanors. 60 days county jail with credit for time served on second-degree misdemeanor and concurrent with each other, and 22 CF 541. $515 court cost, $100 cost of prosecution, $50 PD app fee, $100 PD fee. In 22 CF 541, a judge guilty, 90 days county jail with credit for time served, concurrent with 23 CF 1169. $100 cost of prosecution, $50 PD app fee, $50 PD fee, outstanding monetaries, if any, to collections. And I'm going to just cross out this attached plate and write no insurance.
Yes, Your Honor.
Is that right?
Yes, Your Honor.
So that's a second-degree misdemeanor?
Yes, Your Honor, it's statute 324.022.
All right, so I changed that for you from a first-degree misdemeanor to a second-degree. Okay. And so adjudicated on everything. All right, anything further?
No, Your Honor.
Revoke and terminate probation.
Thank you, Your Honor.
Okay? Thank you.
All right, Mr. Moody.
All right, Mr. Nichols.
Judge, I'm going to ask to pass Mr. Nichols, excuse me, not until the 6th, until a later date. I need to get him evaluated. I think you did August 10th on the other one, Judge.
No objection.
Anna, did I send my court date to you? All right, so you wanted something other than July 6th? Is that what you were saying?
Yes, Judge. There's no
About
way
July 27th?
Judge, I don't know that we'll get it back by then, but we can.
August 31st, how about that? August 10th, how about that?
August 10th was what I'd suggested, Judge.
August 10th, okay.
Thank you, Your Honor.
Okay.
Okay.
Is that it?
Judge, that's all I have this morning in my bucket.
Ms. Flowers, is that it?
Yes, could we approach, could Ariana, or Ms. Leona and I approach about the hearing this afternoon?
Oh, okay.
Judge, I've got him on another case. You guys think you're talking about James?
Yeah.
I've kind of fallen around.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
CQ.
Okay, all right, so we're in recess till 1:30?
Yes, sir.
Is that when we come back for arraignments?
Yes, thank you.
Okay.
We don't have any on the arraignment docket, so we're back to the 2 o'clock docket. We dismiss them anyway. Oh, I'm sure. I'm not.
Here, I'll grab